It is with great pleasure that I present my first bill. House Bill 2005 is a collaborative effort culminating in an agreement with the real estate community, the legal community, and the fair housing community that resolves an anomaly in the law relative to the judicial foreclosure procedure. Based upon this agreement, among the think tank comprised of members from the real estate industry, the legal industry, the fair housing industry, and the senior community, I urge and I vote. Thank you.
Is there any discussion on House Bill 2005? Seeing no discussion, gentleman from DuPage, well, light your lights, ladies and gentlemen. Representative Rebeletti.
Thank you, Speaker. The sponsor yield.
Sponsor yields.
What does this bill actually do, Representative?
Well, essentially what this bill does is exactly what our analysis says, is that it resolves an anomaly in the law. You may not be aware of this, but when you're in a foreclosure proceeding and the time comes in which it's almost over and you want to object to the sale, there are 4 bases to object to a foreclosure sale. The first basis is to argue that you didn't receive notice of the sale. The second basis in which you can argue to stop confirmation of the sale is to argue that the terms of the sale were somehow unconscionable. The third basis in which you can argue that a sale should not be confirmed is to argue that there was some fraud during the process. And lastly, the last and fourth prong in which you can argue that a sale should not be confirmed is if justice was otherwise not done. The issue here is, before you can lodge the argument that you did not receive notice of the sale, you have to put up a bond or you have to put up a guarantee. That makes absolutely no sense. If someone is in the process of being foreclosed upon, how could they possibly purchase a bond or a guarantee to make that argument? I believe that the think tank recognized that that was truly an anomaly in the law. We addressed it. We worked on the language, and in fact, if you look at your analysis, you'll see that there were 3 different amendments before we could finally get the language right. And that was because everyone had a stake, everyone was involved in formulating the language that fixes this problem.
Why did it take us to the 96th General Assembly to get here? Was this an oversight by the other General Assemblies?
I don't believe so. Actually, the last substantive amendments to the judicial foreclosure procedure, and in fact, the law in and of itself, was back in 1987. And Justice Grineman at the time was the champion of that particular piece of legislation. And as time went along, they were addressing so many different issues, and I've read all the floor debates on all of those issues. So to answer your question, it was not an oversight, it was just a very comprehensive piece of legislation that was enacted in 1987.
Representative, what was the amount of bond that the person in foreclosure or the person for the sale would have to put up? What would that amount be?
Well, it would depend, Representative Rebeletti, on the amount of the well, strike that. It would depend on the amount of the bid at the sale. So let's say, for an example, that the sale was for $300,000. If that was the amount of the successful bid, that would be the amount that would be required to be posted as a bond or as a guarantee.
So that's quite an amount to come up with when the person has obviously financial issues. So this would eliminate that requirement.
Absolutely.
So it seems like common sense, but sometimes things with common sense don't always find their way to a successful vote here, but I think your legislation has some potential, Representative. Thank you.
Thank you, Mr. Rebeletti.
Representative Jack Franks.
Thank you, Mr. Speaker. Will the sponsor yield?
Sponsor yields.
Mr. Thapedi, I want to thank you for working so diligently on this bill. And I heard the previous speaker asking some questions. And it seems to me that what you're trying to do is to give a sense of fundamental fairness to one who has a legitimate objection, but not the means to post a bond. Would that be a fair depiction?
That's more than fair, Mr. Franks.
I think those that probably wrote this act some 20 years ago never would have imagined the type of crisis that we're having now in our country with the amount of foreclosures increasing. And I know typically when one has an appeal that a bond is required, and that's probably why they drafted it that way. Would you agree?
And again, I don't know the answer to that question, and after reviewing the floor debates ad nauseum, I still could not come up with the answer to that question. So again, what we're doing today is we're resolving the legislative intent of what this body was thinking back in 1987 with House Bill 3340, if I recall correctly. I know that there are certain members here on the floor today that were actually on the floor back then, because I've seen their names listed in the floor debates.
Well, a lot's happened in 22 years, and I think a lot's happened in 22 months. So I think it's important what you're bringing forward to help protect those folks who have a legitimate defense, such as not getting notice. And I think this is a critical change to the foreclosure law, and I think it's a very good one. And I know you worked long and hard on this, and I appreciate that because you were open to a lot of suggestions, and I know it probably took you a lot longer than you wanted to get to this first bill. But I want to commend you again, and I want to encourage all the members to vote aye on this very important bill, because I think you're going to help people who need help the most.
Oh, you
Thank
said
you
you were
Representative.
addressing constituent needs.
Absolutely.
How did you determine those needs?
The rash number of foreclosure filings
So
that are occurring
what
in
number?
Cook County. Oh, I believe it's roughly over 20-some-odd thousand last year. I said roughly
Oh, okay.
about 20,000.
All in your district?
Well, let me give you a more specific statistic. More than half of the 12,682 foreclosure homes in the state came from Cook County.
Lang, you need another minute? You got it.
Were you finished with that answer, sir?
I believe I was done, sir.
All right. So I don't have much else to say. I think you did a pretty good job answering
Well
my
done,
question.
Representative.
Thank you, Representative.
Mr. Thapedi to close.
Mr. Speaker, I urge an aye vote on this important piece of legislation. Thank you.
Ladies and gentlemen, the question is on Mr. Thapedi's first bill, House Bill 2005. All those in favor signify by voting yes. Those opposed vote no. The voting is open. Have all voted who wish? Have all voted who wish? Mr. Clerk, take the record. On this bill, 116 yes, no noes, no present. This bill, having received the constitutional majority, is hereby declared passed. Congratulations, Representative, on your first bill.